Good morning, good afternoon, and good evening, everyone. Welcome to Fortra's webinar. Today, we want to talk to you about the Digital Personal Data Protection Act of India that is soon to be released in the start of next year. With me, so my name is Anirudh Chand. I'm the Director for Solutions Engineering for Fortra. I've been with the company for about 5 years now. I've come from a very core cybersecurity background with emphasis on compliance, vulnerability assessment, and integration management. With me on the call is Donnie MacColl. Donnie, would you like to introduce yourself?
Absolutely, Annie. Thank you very much. I'm Donnie MacColl. As you can see, I've been with Fortra for 8 years now, and I come from an acquisition. Although it says my title is technical support, I work with a number of support teams throughout the world, covering the security solutions and also the automated solutions too. But probably more importantly, I'm the GDPR data protection officer for Fortra worldwide. So that's why I hope I can add something to the regulations we're going to be talking about today.
All right, let's get started, as you've got quite an agenda lined up for you. So the DPDP Act was recently approved by the Parliament of India, and this is the focus of our discussion today. Now, during this webinar, we'll focus on exactly what this Act defines and how it impacts both the individuals that are the data principals, as well as the organizations that are the beneficiaries of this data collected. Now, all this is meaningless, obviously, if you don't understand what exactly personal data is and its interpretation as per this law. This will be the meaty part of this webinar, something my colleague Donnie will cover in great detail, specifically around some concepts including principal, fiduciary, and processor. Donnie will also expand on how common people will be impacted by this act, with particular emphasis on their rights. I think this is critical for organizations to know and understand, especially when it comes to their obligations to safeguard this data, which, if not done properly, can lead to breaches and obviously subsequently fines. Now, because this is so important, Donnie will talk about this in great detail, so as to leave absolutely no ambiguity whatsoever. And finally, we'll finish this off by suggesting some basic steps organizations can start thinking about if they'll be impacted by this act and how we as Fortra can help. So in August 2023, the Indian Parliament passed the DPDP bill, right? This is literally 5 years after it was first introduced in 2019. I personally think this is a great achievement for India, considering how rapidly its technology landscape has evolved over the past few decades. This act is very timely, and it actually will drag India into the elite club of states that hold value in their citizens' privacy rights. Now, this bill tries to provide a balance between the right of an individual to protect their personal data and the need to process this personal data for lawful purposes by different organizations. Now, when this act was first released, it was inevitable that it would be compared with well-established regulations like GDPR, etc. And there are many, many similarities as well as many differences that the DPDP has with GDPR, but I'll cover 3 of them today. So for instance, if you think about consent, where both the DPDP and GDPR require organizations to obtain consent of individuals before collecting and processing data, there is one glaring difference, and that is that in GDPR, the consent age is 16, which means that anybody above the age of 16 is literally treated as an adult, whereas for DPDP, it is 18, and collecting data for anyone below this age will actually require verifiable parental consent. The other similarity, for want of a better term, is the categorization of data. While GDPR does not really distinguish between classes of data, DPDP has introduced the concept of data fiduciaries, a concept Donnie is going to cover later on during the webinar. One other thing that I want to mention here with regards to GDPR is what happens during data breaches. So GDPR actually requires all personal data breaches of the impacted individuals to be reported, but only if the breach will result in high risk to the rights and freedoms of that impacted individual. This is not the same for DPDP, however. There is absolutely no such thing, and every breach needs to be reported by the data processors and fiduciaries to the DPO and relevant authorities, regardless of what impact that breach will have on individual. Now, if you talk about the goals of this bill, it can be summed up in one line, I believe, and that is the right to privacy. What this really means, in a nutshell, is that any entity that handles, collects, or processes any Indian citizen's personal data are directly responsible to ensure the privacy and security of their data is maintained, and that these organizations seek consent before collection. So that's really vital. And then finally, this act will come into effect at the start of next year, but rumor has it that companies might be required to comply by the middle of next year. So who does Digital Personal Data Protection Act really apply to, right? As India grows into this digital superpower, this act will help bolster data protection and accountability for entities that handle all Indian citizen data. Now, this act really covers both digital as well as non-digital data that are subsequently digitized. So think about physical medical records, for instance, that were digitized, they will all be impacted. Another key aspect of this act is actually its scope and how far it extends beyond the borders of India. And this encompasses digital personal data processing activities overseas as well. So what this means is that this extension actually applies specifically to any organization that is offering goods or services to individuals in India or engaging in the profiling of Indian citizens. So in doing so, the Act fortifies data protection measures, not only within India, but also concerning Indian citizens' data handled overseas. Now, a point to note here, though, is that there are some entities that will be exempted by this Act, specifically central government and other government bodies. What the exemption is going to be, at what rate it's going to be, that depends on the nature of that governing body. The degree of exemption can depend on their functioning, for instance. So law and order entities might have more loose exemptions, more broader exemptions, whereas other bodies like municipalities might have lesser exemptions, etc. And then there are other entities, including those that use publicly available personal data or use data for research and statistics. And then finally, think about companies that process the personal data of foreigners, like outsourcing firms, and they will be exempt. Though these firms actually might be impacted by other regulations like GDPR, etc. So in the next slide, Donnie's going to elaborate more on what I've introduced, starting with the definition of personal data.
Thank you, Annie. Okay, I'm going to spend quite a bit of time talking about what personal data is and the differences between other regulations. So the question is, what is personal data? The question I want to ask is it the same as PIIs? Is it the same as personally identifying information, such as we have in the US typically? And is it the same as GDPR, the General Data Protection Regulation, personal information? Now, the reason that Annie and I talk so much about the GDPR is so often it's a good comparison to make for all regulations that have spawned or started since 2018, when the GDPR became effective in law, because most of them are based on it. Now, most are not as strict as the GDPR, and the DPDA is no exception. There's areas where it's not as strict as the GDPR, and there's a few differences as well. So to put things in perspective, so PII has a limited scope to what comprises personal data. It includes things such as your name, your address, your date of birth, your social security number, which in the US, if you have somebody's social security number, you pretty much have the keys to the kingdom, do quite a lot with it. So the scope isn't as wide. There's some very important information there. It also includes things such as banking information. Now, if you jump across to the GDPR covering the UK and European citizens, personal information in the context of the GDPR also references, so there's lots of information we already that is classed as personal. It also extends to items such as photographs, social media posts, preferences, location information, IP addresses. So, for example, the IP address of my cell phone can be, or location information of my cell phone could be found back to me. So that could help with other information, identify me. It also includes CCTV images and email addresses as well, personal email addresses as well. So it's quite wide. The DPDP Act applies to the process, and as Annie said, of digital personal information. So just to expand on that, that's broadly defined as data in digital form. Now, whether that's collected in digital form or if it's collected in non-digital form and then digitized, it has to be about an individual, and it has to be data that could identify that individual. So it encompasses pretty much everything that we've spoken about that can be digitized. Now, interestingly, with the DPDP, there is no difference in the Act to categorise personal data and sensitive data, unlike other regulations. So it's good in a way because it means that all personal data is personal data. What's exempt? Aggregated data used for household purposes, and publicly available personal data. Now, one item I did note, and I will just say, as Annie said, this is not in force yet, so it is subject to change. But one item I did note that stood out to me is that personal data is exempt from processing if it's used for journalistic reasons. I find that, I'm not sure what the intent of that is. I find that quite unusual. I find it interesting. So basically, there's a law to protect all my personal data unless it's going to be on the news or in the newspaper, then it can be shared. So I'm not sure what the intent of that is, but that will become clear, no doubt, as the regulation is refined. What is really good about this Act for Indian citizens is there has to be a legal basis to use their personal data. Now, consent is by far the strongest reason for using a legal basis for using personal data. In fact, it's stated that this is the reason you can use it. There are other reasons as well that fall into line, and I'm going to touch on, but consent is the strongest. So with consent, you have to give people consent to use your data. Now, to give that consent, it must be freely given. So the user, the person, must not feel coerced or pressured to give consent. You can't be bullied into it. It must be unconditional. The consent cannot be made conditional on anything else, such as you can only use this service if you give us all your personal data. So it has to be, you have to separate the two. Consent must also be unambiguous. So the person given the consent must be clear about what they're consenting to. So if they're asked, if you can use somebody's personal data, you have to be very clear, very concise, very precise about what it is that you want to do and what people are agreeing to. It must be specific. So the consent must specify the purpose for which the data is being collected and processed. Now, this is really important because to do that, that really generally, in my opinion, needs to be at the first point of contact. Now, whether the first point of contact with a company who may use your data, for example, is a website, that's okay to have it in the privacy policy saying, this is the data we'd like to use, can we have your consent? This is what we're going to do with it, this is who we're going to share it with. If it was a telephone call, now you don't have to read through the entire privacy policy, but the first point of contact, we should really say to the person involved, we're going to use your data, we're going to record it for training purposes. There are other reasons we will use your data and the extent of it and how long we keep it. That's in our privacy policy. Would you like a link to it or a terms and conditions? So I guess what I'm saying, it's empowering individuals, which is absolutely brilliant. I'm really pleased about it. The consent basis must be informed. The person must be given enough information about their data and how it will be used so they can make an informed decision about whether they want to give consent or not. Now, there are other reasons that aren't specifically specified, but that do fall into legitimate interest, where the consent basis is not so strong. So, for example, if I went onto my favourite online shopping worldwide global system to buy anything, a book perhaps, to be delivered to my house, I wouldn't have to ask for consent for, the company wouldn't have to ask my consent to use my personal data because there's a legitimate interest there in that. And the legitimate interest must be in favour of me, the person whose data they want to use. So if I want to buy a book, I'm going to give somebody my name, my address, my email address, possibly my telephone number, definitely my financial information as well, so they can process the payment. they don't have to ask me for consent for that. It's a legitimate interest in my favour for them to have that. The other reason, so that could also be, for example, buying a car or an insurance policy or something similar. Life and death. Now, in the event that something tragic happened or you're unable to give consent, then in the life and death situation, people can access your medical records, your next of kin, your contact is, various things there. So you don't specifically have to give consent there. So it's very, very strict, but it's also very, very sensible. I particularly like lawful purpose. So another legal basis that you can use data under this Act is a lawful purpose. And as the Act isn't quite complete yet, what it actually stated, and I really like this, is you can use my data for any lawful purpose, and that is anything that is not unlawful or restricted by law. So again, so there's still some fine tuning to be done, but it's certainly going in the right direction, which I'm generally really pleased about. Now, Annie mentioned there's different categories of people, really, or roles, I should say, within this Act. And what I've done is tried to list here is what they're called here in the DPDP and what they're called in the GDPR, and really a brief understanding and explanation of what it is. Now, a data principal is the individual whose personal data is being processed. That's known as a data subject in the GDPR. It's a person, it's you, it's me, it's our data. So it's the person whose data is being referred to. So data subject or data principal is the person whose data we want to do something with. A data fiduciary is a powerful role. There's a much more powerful one I'll come to in a moment. There's a powerful role and it's classed as a data controller. Now that could be a person or company who decide how the data, once they have it from you, how it's going to be processed. So that would be what processing that data is going to happen. It may be to enact an order. So with Fortra, it may be we need financial information to provide you with software and services and ongoing support. And to do that, we may pass that outside of the country you're in to our US headquarters. We may pass it to support teams in the UK, in Europe, in APAC, whatever. So we would control, we will tell you all this, we will control how that data is processed. And we would tell the data processor, so the entity or people that are actually processing the data, what they have to do with it. The data processor, the next one down, cannot make any decisions about your data. They can only do what they're told to do by the data fiduciary. So the processors have a legal right to make sure your data is protected, but they can only do with it what the data fiduciary tells them to do. And then we have the data protection officer. The data protection officer is very, very similar. There is another role I'll come to in a moment, very similar to items that the data protection officer has to do within the GDPR, and really that's a point of contact. So if in the event of a potential data breach, or you're not getting what you want, if you want to exercise some of your rights, that we're going to come to the next slide, that you have a lot of rights as a data principal. If you're trying to exercise rights and you can't, you can complain to the data protection officer if one has to be created. So I'll come to that in a moment. So as a person, as a principal, you've got lots of rights with your data if you decide to give consent for people to use that. So there's a lot of rights to mention here. You can see them all on the screen. So you have the right to be informed about the processing of your personal data. And I mentioned that before. That's the first point of contact, privacy policy, terms and conditions, maybe told on the telephone. You have to be informed about what we're going to do with your data, who we're going to give it to, why we're using it, how long we're going to keep it for, how you can delete it, how you can ask for to exercise some of the other rights as well. So lots of information you must be told about before we start processing it. You also have the right, interesting one, to access your personal data. Now, there is a difference here under the GDPR, there is under the DPDP Act. You can request access to your personal data, a copy of it. Under the GDPR, that means we have to give you a copy of everything we hold on you. Every email with your name in, we have to redact information we can't share. CRM details, entries in financial systems, if you're an employee, HR data, we have to give you access to it. We can either give you a copy of it, we can share it on the screen, or a combination of two. here at the moment, I say at the moment, so some of these terms to talk about, I think will change. At the moment, under the DPDP Act, it's a summary. So we do have to give you a copy of or access to your personal data, but quite a high level summary of it. I think that will change. I absolutely think that will change. Once this becomes law, within 24 months, I think it'll be very similar, if not the same, to GDPR. You have the right to have your personal data corrected. So if you believe the information that is stored or processed by anybody is incorrect, you can ask for it to be corrected and made right. In the GDPR, there's an additional bit there. You can stop people using your data until it's been corrected. So that ties in with the access to personal data. You ask to see your data, you say that's wrong, can you please change it? So at the moment, you can ask that to be corrected and wait for it to be corrected. There's no mechanism to stop it being used in the meantime, and like GDPR, again, I think that may come. You can have your personal data updated or completed. So if there's information, now this could be, for example, if you're applying for a job, or if you were applying to borrow some money, for example, if you think the information they have about you is not complete, you can ask for it to be completed. It also needs to be updated. So if you can imagine, let's say in January, so I give people consent to use my data to perform something, maybe buy something or apply for a job, and then 3 years later, things have changed. I can ask my data to be updated to the latest version, can have that as well. A very powerful one. You can ask here, the GDPR, it's called the right to be forgotten. You can ask to have your personal data raised. This is really powerful, and I really like this. I use this to, I can ask people to stop sending me marketing material. And because I get inundated, as I'm sure lots of people do, I can ask that to stop. It's a law that if I ask for it to be stopped, they have to stop sending it to me. If not, I can report them to the equivalent of the data controller. But you can ask for it to be erased, and it has to be done here within 30 days. It's a reasonable amount of time under the DPDP Act. I don't like that at all. A reasonable amount of time I don't like in any law, because I go back to many years ago before the GDPR was in effect with the Data Protection Act, and a large American email provider disclosed several million records, data breach basically, and nobody knew about it until over 2 years later, when they said, yeah, we had this data breach 2 years ago, all this information was shared, this is what we've done about it. People tried to complain, and they said, well, this is terrible, you know, our personal information was shared over 2 years ago, you did nothing about it. They said, we did what we could, and we did it in a reasonable amount of time, which is 2 years. We're a big company, we think that's reasonable. To give you an example, with the GDPR, 30 days is the maximum you can wait before you have to give somebody a copy of the data, or you have it corrected or updated or completed. So hopefully that will come in as well. You can also nominate another person to exercise your data privacy rights. If, for example, you passed or you were unable to execute or relay your rights, you can give another living human the ability to exercise your rights. And you have the right to submit a grievance to the data fiduciary about any of the rights or about anything else about your data. If you remove consent for people to use it, or companies to use your data, and they don't stop using it, you can complain to the data fiduciary, and they need to listen, because this is a great act that's coming in with lots of penalties to make sure that people do the right thing. Right, some of the obligations under the DPDP Act. Organisations, as we mentioned, must contain consent before they process your personal data, unless an exemption applies. There's a number of exemptions, I won't go through them all, but some of them could be, like I said, legitimate interest. Some could be if it's the government that wants to use it, or it's a criminal an incident or something like that, or healthcare. So there's certain exemptions there. Again, we mentioned this, can only use personal data for the purposes for which was collected. So, for example, we at Fortra could say to our colleagues who are affected by this act, this is the information we'd like because you want to buy some data classification software from us. This is what we need to execute that, provide you with the software, the services, and the support. We will tell you that that's all we are legally obliged, even now, before this happens. Oh, that's all we would ever do. We would be legally obliged to only use it for that. We couldn't then, for example, go, oh, do you know what? I think we'll just contact the Centre of Marketing on other items to do with our automation solutions that are nothing to do with our security solutions. We could just send you lots of money. We can't do that. We can only use it for what we said we're going to use it for, what's collected, unless you've given us access to do something else with it. We couldn't, for example, bring in a new system and think, yeah, it'd be great to pass the information on to them. We can start targeting people. We can't do that. So there's lots of items there. This is a huge one, absolutely huge. And this is where Fortra can absolutely help you with years of experience with security and automation, and really importantly, automated security, but also having to adhere ourselves and also to help other people from an educational and a technical angle comply with regulations such as the DPDP Act. Now, organisations, really important. Organisations must take appropriate technical and organisational measures, and he said at the very beginning, to protect your data. That's what we're doing, we're protecting your data. Technical and organisational are the identical words that are used under the GDPR. Technical is you must have software solutions or hardware solutions, if it has to be, in place to protect data, whether that's a very small subset here. You may, if you encrypt data, fantastic. If you can anonymize it, pseudonymize it, that's absolutely fantastic. It may be data classification. It may be you perform penetration testing. It could be any of the various things we can help with. So technical are basically software or hardware solutions to protect, encrypt, look after your data. The organizational, and this is where there's one solution, and I'm no technical person, I'm not trying to sell you stuff, I'm just telling you where I get excited about things. Organizational measures are, we talked about the rights that people have and the right to redress, right to complain. You need to have processes, organizational processes in place to make sure that somebody says to you, I would like to access my data, please, that you know what to do. So this has to be from the top down. This is not an IT problem. It's not a security team problem. This is a challenge for an organizational level, top down. So every employee, regardless of their role, must recognize a request for somebody who says, I want a copy of my data. I want you to change this. I want you to stop processing. They need to know what to do. Extremely important to that. Now, the reason I get excited about this is we have a company called Terra Nova that provides the most incredible security training. It is important that every single employee has at least annual training, and certainly initial training that is auditable, that you can recognize, you can prove, just to make sure that your company stands above everybody else to say, look, we train all our employees, this is what we do, this is how we deliver it, and we do annual recertifications as well. Very, very important. So recommend Terra Nova is something you look at. I mentioned this, you have to respond to access to requests, correction. So again, you have to have a mechanism in place and you have to do it. Failure to do so within a reasonable amount of time can result in a fine or other penalties. And they're huge, some of the fines. And as Annie said, different from the GDPR, better, stronger than the GDPR. You must report data breaches to the Data Protection Board of India, government body. You have to. Within 72 hours, that's the same as the GDPR. What I would say, it doesn't define this in the Act, but I think this is the intent, and again, I think it might change, is when it says within 72 hours of becoming aware of the breach, I would extend that to a suspected data breach. Now, 72 hours, you may think, I think that might be a breach. I start looking at it. You may not know if it's a breach within 72 hours. You might not know it's a breach within 72 days. I would take that any suspected breach, which is what the GDPR makes you do, that you report it. There's two reasons for that. The DPDP Act is not there to beat you up and find you lots of money. It's to make sure you look after people's data. So the Data Protection Board of India, I'm sure, will help you, as we have the Information Commissioner's Office in the UK and various other regulatory boards. They help you with the data breaches. Or suspected data breaches. So absolutely report it at the earliest instant. Even a suspected data breach would be my big hint and tip. Okay, so what is a DPO? What is a data protection officer, and do you need one? Well, if the government determines there's a need to appoint a DPO, or to use the actual terminology, if the governmental significant data fiduciary state you must appoint a DPO, they base it on a number of criteria. Again, some of it's to be ratified. They're based on the volume, typically high volume, sensitivity of the data. So this is whether they determine you need one. They also base it, some great words in there, the potential impact on the sovereignty and integrity of India, if the processing of data could be a risk to the electoral democracy or the security of the state public order. Now, the significant data fiduciaries shall, these are items that they'll do, appoint a DPO, if they determine that you need one, who shall represent the significant data fiduciary under the provisions of the Act. Bearing in mind the significant data fiduciary is a government body stroke employees, so you're representing the government within your company, for example. You must, as a data protection officer, you must be based in India, so you must physically live there. The role must be responsible to the board of directors or a similar governing body of the significant data fiduciary, and you will be the point of contact for the grievance redressal mechanism under provisions of the Act. Now, I'll go a little step further with that. I'm the data protection officer for Fortra worldwide. I have to report straight into the board. I have to act in a certain manner and do certain things. One great thing is I can never be dismissed. I can never have my role removed if I report a data breach and the company doesn't want me to. It does happen. It will never happen here. It does happen, especially in smaller companies where they go, oh, don't report that, we might get fined. If I can't, I am legally bound to report something if I believe there's been a breach. I cannot be removed my role from that, and I think that will be the same for this as well. The data protection officer must also perform periodic data protection impact assessments. That's another thing from the GDPR. To process, comprising a description of the rights of the data principles, purpose of the process, and the various other things. The data protection impact assessments are really good practice to do as well when you implement a new system. And at the very beginning said, the data, if it's a significant risk to the rights of a person, how do you know it is if you don't do an impact assessment? See, say, for example, we may implement a sales tool that records calls. Well, if you're going to do that, you need to do a data protection impact assessment, one, to make sure you're allowed to do it. You may have to ask for consent again to record calls without telling people, you pretty certainly will. And also to see what happens with that data, where it's stored, if it's stored in a country you're happy with it be stored in. So you have to do a data protection impact assessment, and that's up to the DPO to do. Penalties. So if you do something wrong, now I will go back to the GDPR unless on purpose or if you haven't bothered. So what we have with the GDPR has been law since 2018. It was actually 2016 it became into force, but was not enforceable. So those really, it's 2016. It's mature. It does change, but again, it's the intent. The intent is to secure your data. If you do something wrong, it's not to beat you up and fine you straight away. That's not the immediate point. It's to help you make sure that you put in stronger mechanisms. If, for example, a company has a data breach and there's no technological and organisational, remember them from a while ago, if they've not done anything, they absolutely deserve to be fined, and to be honest, they will probably close down, and I've seen that happen too. If there's processes in place and they just hadn't been able to afford to put everything in place, but they've simply prioritised, that's okay too. You know, it's the intent, it's not to beat people up. I really like this. With this, I mean, India being fantastic about this. The penalties, look at these are huge, right? These are not all of them. There's a certain category, there's lots of categories you can go through. Data controllers, if you remember that role, are required to report personal data breaches, which includes, now this is where people think data breaches where data has been exposed. A data breach includes unauthorized data processing, you weren't allowed to do it in the first place, or somebody else gets access to it. Disclosure, that's what people normally think is a data breach. Alteration, if somebody changes your data, it's your data, remember, under this Act, it's your data. Somebody changes it, that's also a data breach. If they lose it, if you leave a laptop with information on or a data memory stick, and we've had that in the UK, government ministers leaving documents, and also in this case it wouldn't be digitized, but digitized information on a train, for example, that's a loss, that's a data breach, has to be reported. If you do any actions compromising data confidentiality or integrity or availability. So ransomware, again, we can help you prevent against that, but with ransomware, if the data is not available, that is a data breach that has to be reported as well. The reporting obligations under the DPDP Act are in addition, this is important too, they're in addition to the existing reporting obligations already in place under India's Computer Emergency Response Team rules. And remember the important bit, breaches, and I would go as far as suspected breaches that I keep going on about, must be reported to the Data Protection Board of India within 72 hours. Now, some of the penalties you can see there: fail to prevent a personal data breach, breach of duties. So breach of duties, you're not doing what you said you do, $120. Okay, it's not a lot of money, is it? Look at the bottom one, the failure of security to prevent a breach. This again goes back to technological and organizational. If you didn't prevent a data breach because your employees just didn't know, because they didn't have Terra Nova training, you can get fined up to $30 million US. That's how a lot of companies will close down because of that. Anyway, worth looking at. I won't go on about that anymore now. And now I'll be quiet and I'll pass back to Arnie.
Brilliant. Thanks, Donnie. And that was really a good summary and assessment, of all these principles. So, what is private data? You spoke about the obligations, the responsibilities of different entities with regards to this act. And you also elaborated a lot more on the roles and responsibilities of all those different data officers, specifically the DPO. And then, of course, we had a quick look at the different fines, right? So we've got all this information, but what are the next steps, right? What can actually organizations do to comply to this? How do they go about doing that? And some of the clues actually lie in the DPDP Act itself. So if you ask 10 different DPOs, they will each differ on how to go about protecting the organization's data. Now, there are definitive guidelines on how to go about, and it's critical to get the basics as well as the first steps correct. And for me, the first and the most obvious step is to actually know your data. There's really no point talking about protecting any data if you don't know where it is, how it's classified, who's got access to it, etc. So it's an obvious place to start. We need to understand what data we have. Is it structured, unstructured, who's got access, etc. We also need to understand its classification process and its entire life cycle from inception to destruction. This is important. And then this inventory process is the foundation to complying to this act. The other thing that we must consider once we've got an understanding of our data is that we also need to create an inventory of all the third parties who we may be transacting or handling this data with. Now, many organizations rely on third parties for various aspects of their business, which means these parties are invariably required to access this data. Now, this might require updating current agreements. It also might require ensuring all parties are aware of their responsibilities and obligations, etc. It is critical to have a central registry to ensure the audit of access to this data by these third parties. Organizations also must understand that access to other people's personal data is, no longer a right, but now a privilege, and to treat this data accordingly. So I think it's therefore critical to ensure that we have strict policies in place that govern who has access to this data and what they can actually do with this data, as well as an audit on all transactions. What this might mean is that we would need to create a DPDP Act compliant data privacy policy and a number of processes as well to design a consent mechanism for anybody, for organizations who are requesting access to individuals' personal data. A consent mechanism will definitely help define the different consent types, which in turn will also help organizations develop a more user-friendly consent process. It doesn't have to be cumbersome. And then if you talk about data security, it must not be limited to process. And I think Donnie spoke really well about training your employees. And this should be part of the culture of an organization. Training all employees without exception on how to handle different types of data is often overlooked and underrated, but it can also be the most impactful in securing data if managed correctly. And coming from a cybersecurity background, I know that humans are the weakest link when it comes to issues like data protection. One aspect of training we must not forget is breach management and reporting, which is critical, reporting that breach, which is critical. And we also know that failure to do so can result in massive fines. So I think there should be proper emphasis and function to this step. And then finally, don't forget, right? All of these above steps need to be constantly improved. They need to be constantly reviewed and actually assess what works, what doesn't, and refine this process time and time again. Remember, the DPDP Act is there as a guide to help organizations meet the data privacy requirements. It should be treated more as a carrot, not as a stick.
Excellent, thank you, Annie. Now, I'm very much aware that we've covered lots and lots of information, lots of terminology. We spoke about a number of solutions, a number of security areas. I'm just going to throw much more information at you. No, don't worry, we're here to help, so you can contact us afterwards, obviously. I like this slide, although I know it's very busy. This is talking about the MITRE ATT&CK framework. Now, it's nothing to do with Fortra. I just want to explain what it is and why I like it. The MITRE ATT&CK framework was created in 2013. There to do a number of things. It's create a comprehensive document of tactics, techniques, and procedures that cyber attackers were regularly using to breach the defences of individuals and organisations. Now, very much 10 years old now. Since then, it's grown to be a global knowledge base, which helps to standardise defensive security and remains accessible to all security professionals. Now, it is a framework. It's freely available to look at. The framework continues to be updated, and you've mentioned that, and with the processes as well. This continues to be updated, helps to bring together the intelligence of cybersecurity experts around the globe to better defend against the ever-growing threat landscape. We're constantly being attacked. Fortra has got comprehensive solutions in all these areas, but particularly in the areas of risk mitigation, detection, identification. We have testing, we provide robust security and compliance solutions as well at all levels, brought together by the platform, which is a way that you can bring together multiple solutions with a single point of view to aggregate the data from the multiple attack vectors. So it's just to touch on that, something for you to look at after the event, just to let you know that we have areas that we can help you with. Now, I talk about solutions, help with education. We are here to help you. So you don't have to buy services or software or support. We're here to help. So any questions you got, you can get in touch with us about any aspect of security. We've got plenty of people here that can help. To bring it to a smaller slide and to perhaps give you a bit of a starting point of some of the areas you may want to look at, these are just a few of the areas we can assist you with to meet and exceed all the requirements of the DPDP. And now, bearing in mind, it will change. It still hasn't been fully complete, but I know from the regulations that we have to adhere with, and we help other companies adhere to, that we are going to be able to help in every area. You don't need to do everything at once. The hardest part is always making a start. I know there's been so much information, it can be overwhelming. What I would say is make a start. It's a bit like going to the gym. The hardest part of going to the gym is leaving the house in the first place. So I recommend start off by reviewing what you've got. Just have a look at the solutions you have in place, the areas you've got covered. Forget about them. You don't need to worry about them. If you've got something in place, then forget about that. Look at the areas you haven't got covered and then prioritize them. And this is, again, where I think for free, I think we can help you. If you struggle prioritizing, just ask us here at Fortra. We will definitely help you to determine the best route to take to make a start. Don't try and do everything all at once. If you can do 10% of what you need to do, you'll get more time to concentrate on the other 90%. But don't try and do all 90%. Pick another 10%, pick another smaller bit, break it down. Please don't suffer from analysis paralysis and make a start. Is the biggest tip I can give you. Back to you, Annie.
I love that analogy of going to the gym. I suffer that every day. So I can definitely relate to that. Okay, so to summarize, right, the primary goal of the DPDP, and let's not forget this, is to establish a framework for the protection of personal data and privacy of its citizens, right? This is basically all that it's about. We've spoken about the key requirements, but let's just summarize some of them, right? Probably one of the most important is consent, which is to obtain valid consent from individuals or from parents in case of minors before collecting and processing that data. The other aspect is that of the data processing principles themselves, and this alludes to things like how you actually collect that data, where you store it, its integrity check, confidentiality check, and also using the data to its minimalistic purpose, as Donnie had spoken about previously, just to use it for its intended purpose and nothing else. Individual rights are definitely critical, and these need to be regarded when collecting personal data. And these rights can also expand to things like, as Donnie mentioned, accessing the data to be able to correct, modify, or even erase data, and also in some cases object to the actual processing of the data itself. And then finally, breaches, right? This is where it all comes down to, all businesses are there to protect their bottom line, to make money, but if they are not responsible and they are not compliant to this act, it can result in heavy fines and even possible shutdown of shop. So this is something to be looked at. Once again, key dates, don't forget, the effective date for this act to come into effect is the 1st of January next year, and compliance is expected to start in the middle of next year. We've got a number of resources if you head across to our website. One I personally like is the Digital Personal Data Protection Guide. This is something that we've actually built specific to the DPDP Act, and this is something that you can acquire on that link over there. Don't worry, we can share that link with you later on, but this will give you a good understanding of the DPDP, your obligations, a lot of stuff that we've covered during this webinar, but in a nice tablet format. So a bit about Fortra. A lot of people don't know this. You might be wondering, who actually is Fortra? Well, we started as a company way back in 1982. We were called Health Systems before, and we focus on solutions for IBM I-Series and its predecessors. We changed our name to Fortra in November of 2022, a name that reflects and recognizes and celebrates change. For the past few years, we've started, starting back in, I think, 2008, we went on the war path to acquire a number of network and security-focused companies. And by 2015, we'd completed 15 acquisitions, right? That's how strong we are now. Our mission is clear. We want to provide solutions to organizations seemingly unsolvable security challenges. And while we are our headquarters is based in Minneapolis and Minnesota, we have offices located across the United States that are up to sales and support. And we also have strategic locations in India, Australia, England, Germany, Switzerland, Spain, Canada, and Argentina. And that's where we've got support and development as well. So that's it pretty much from us. Thank you so much for your time on this webinar.